Hello, everyone, and welcome to today's webinar, Challenges and Alternatives for Potential Second Chances. I'm Marianela Mansour here on behalf of our wonderful team here at Joorney, and it's a pleasure to be your host for today's session. We're going to wait for a little bit as we usually do, and as I love to ask on the chat on the right-hand side, where are people joining us from? Let's see. Let me see. We have more than 200 people registered today, and I see that we already have more than 50. Ottawa, Canada. Amazing. Richmond Hill, Ontario. Oakville, Ontario. Mississauga. Hi, Anu. Familiar names. Thank you for joining. Good morning, Mohammed. North York. Mississauga. Wonderful. Today's topic is a very interesting one, so I'm happy that people are going to be here. We have two wonderful guests that I'm going to introduce shortly, and you're going to really enjoy this topic today because a lot of things are happening these days, so it's a breath of fresh air to know that there's reassurance of opportunities, alternatives to what is happening. So really happy to bring this to everybody today. Okay. We have a lot of questions to cover today. So we're going to get started. We have more than 70 people joining. We're probably expecting around 120 and many people watching afterwards as well. So let's get started. So hello, everyone, and welcome to today's webinar, Challenges and Alternatives for Potential Second Chances. Like I mentioned, my name is Marianela Mansour, here on behalf of our wonderful team at Joorney, and it's a pleasure to be your host for today's session. While we get settled, let me take a moment to reintroduce Joorney to those of you who may be joining us for the first time. At Joorney, we help immigrant entrepreneurs with their business plans for their applications. We focus on quality, reliability, responsiveness, and speed. And we're very proud to play a small but meaningful role in our clients' life-changing journeys. This webinar was one that I was very interested in hosting. We have two amazing guests, as I mentioned, to talk about this topic. As you know, a lot of things have been happening lately in business immigration in Canada and in the world. We've seen programs get closed, others shifted to have less opportunities, and also beyond that, we're also seeing a pile of pending cases and even refusals beyond requirements. And those are some of the topics and questions that our guests will be addressing today. Additionally, we're also here to bring solutions to some of those applicants that have not had success in the past or have had delays and might need a second chance as well, hence the title of our webinar. Now, if you've been working with a Canadian startup visa or any other immigration program over the last few months, I'm sure you had questions that are very difficult to answer. Maybe you've seen more refusals than before, delays, as I was mentioning, or heard conflicting stories about what is it that IRCC is really looking for. Maybe you're supporting clients who have done everything right on paper, but still have had issues in their path. So that's exactly why we're here today. We'll be talking about the challenges in Canadian business immigration system, recent legal developments, and what alternatives or second chances may still exist for applicants who've hit roadblocks. To help us navigate these topics, we are joined by not one, but two incredible guests who bring both legal insight and hands-on experience to the conversation. First, we have Panthea Jafari, an immigration lawyer. Let me put her on the spot here while I introduce her. Um, Panthea Jafari, an immigration lawyer known for her leadership in group litigation efforts tied to these programs. Pantea brings a unique perspective on what legal options are available and what new strategies are starting to gain a lot of traction. And joining Pantea and me is Zainab Siai, an immigration lawyer with extensive experience advocating for clients in the startup visa and self-employed categories. She's been at the forefront of efforts to hold the system accountable and improve transparency for applicants. Zainab, Pantea, thank you both for being here today.
Thanks
Let
for
me
having us.
get everybody in the picture. I need to do this. Let me try this. 1 second. There we go. Let me see if I. Oh, okay, perfect. Now the three of us are here. Welcome, welcome to both of you.
Thanks for having us.
So a quick note before we begin. If you have any questions throughout the session, please add them to the question tab on the right-hand side of your screen, and we'll have time at the end to get as many as we can. All right, we're ready to get started. Let's dive in. Ladies, you're ready? Welcome, welcome.
Let's do this.
Wonderful. So let's start with the big picture. What does the current Canadian business immigration landscape look like, including the results of the elections and also particularly for SUV and the potential return of a self-employed program? And this question is for both, so I'll let Pantea lead, and then we'll have Zainab's opinion as well.
What does the landscape look like? Not well, almost abysmal, unfortunately. There are only two programs federally presently. It's the self-employed program, which is on pause, and the startup visa program, which is rife with problems of all kinds. Both aren't doing necessarily the greatest. Neither have garnered trust and faith in the immigration system. And we're getting a bad rep. We're losing a lot of business clients, and we don't have an entrepreneur program, which, aside from these two silo programs, which people are generally looking for. So there are a lot of ideas as to what can change, what should change, what needs to change from lawyer groups, from industry that the government may or may not be listening to, seemingly is not listening to. And with the election, we've got the same ruling party. So potentially maybe not much will change, but it is possible that under Mr. Carney's leadership, who's more finance oriented, because what's happening is not only bad for our reputation, it's really bad for us economically, in my opinion. So it's possible that things will shift a little bit. Let's unfortunately wait and see is the only option we seem to have, other than the actual action-based items that we've got in store for you guys.
I echo what Pantea is saying. Unfortunately, the situation is a bit bleak with regards to business immigration. Right now, there are very few options. Some of the other pathways that applicants were trying to use in terms of work permits that would eventually lead to permanent residency are effectively not workable anymore with the removal of the job offer points. And, the PNP programs, the limited programs that there were, are going to be even fewer because of the cut in quotas. So we are left with essentially only the startup visa as the pathway that's a business pathway right now. And it's I don't think it's very realistic to think about it as a large scale program because of the limitations that were put in last year. But I'm cautiously optimistic that at this point in time, we can think that there may be positive changes on the horizon. And I say that because with everything we say about the immigration landscape in the US, one of the first things that President Trump said was that he wants to do a golden visa. And it's not just that he wants to do a golden visa. I think that opened up the conversation within not just the US market and society, but also raise that question again within the Canadian market and Canadian society of, can we have more robust economic and business, and investor programs where we are attracting money and talent and so on? And I think if we can capitalize on those conversations. This is a unique time for us to do that because it is a missed opportunity. I agree with Pantea. It's not just an immigration matter, it's an economic matter. And business immigration can really help us at this critical point.
Definitely. Thank you. Thank you so much for the perspectives. As you know, we have operations in both Canada and the US, so we've been seeing the impact on both sides. As we were mentioning before we went live, it's the uncertainty that puts everybody on hold and hurts the business, right? And we're seeing it across the board. And we're also seeing people from the US want to go to Canada, people from Canada want to go to the US, and also people abroad seeing like, okay, what are my options? And then, I mean, and then the limitations come. So that's what we're seeing everywhere. Pantea, from your perspective, how is the startup visa program being treated these days? Have there been any recent changes, or should we expect any soon?
So, unfortunately, from my perspective, what I'm seeing happen in the SUV program is exactly what happened in the self-employed program. So what happened with the self-employed program, like the SUV, is that it was a pretty small program for the most part, not a lot of people necessarily resorting to it, and then it ballooned. It suddenly came on whatever amount of people's radars, and the inventory just blew. And there was no inventory control, no caps. And when the inventory got out of hand, then became what to do with it. And unfortunately, unlike some other inventory management issues in the past, like the Federal Skilled Worker Program, the Quebec Inventory Investor Program, where the government made an open announcement saying, okay, you know, we kind of screwed up, we took too many, we can't process it, and openly closed it. What happened in the self-employed program, which we proved through a 4-year litigation, is that the government instead made a deliberate and calculated decision to suddenly change the process and the standard by which to assess those applications. What that means is they basically started coming up with excuses to refuse applications and to clear the inventory. And that is exactly what I'm seeing happen in the SUV program, which I actually foresaw happening at least about 3 years ago when I started writing about this. I saw the inventory growing larger and larger without a corollary kind of increase in officers processing these. The processing time started ballooning, the inventory started ballooning, and inevitably that was going to lead to an inventory management problem, which then the government would again be asked to either make a public announcement and do something about, or, you know, these behind the scenes type of things that we're coming to now. And the behind the scenes is what seems to have been what won out in the end, because what we're seeing in at least the last year is really what I can call excuse-based refusals. So it's again a sudden change of policy and standard to be met that is being changed without announcement. So a very clear example is a lot of SUV groups will know, and their stakeholders of all kinds in this program will know, that when you get a letter of support, a commitment certificate, and you lock in who you mark as an essential and non-essential team member, you know, business realities happen, personal realities happen, and there needs to be some changes to those group compositions down the line. And for a very long time, those group composition changes by revisions to the commitment certificate were being accepted and processed without problem, and the PR applications approved in the end. Now, suddenly, they are being treated as a determining factor. And if the person locked in as essential at the very first LSO and time of filing is no longer part of the group, has withdrawn or been refused a PR application, then the group is being refused. And several other examples, which we'll get into later, but that seems to be what's happening. And not only are they already having inventory management issues, but when you look at some of the ATIPs in this program behind the scenes, you see government agents speaking to each other and being open and very honest, saying, based on present inventory, we see a 6-year processing time for the inventory we have at present, and that ATIP's from 2024. and they haven't closed the inventory, paused it, and are continuing to take in more every day, but they're posting 40 months processing time. That's not honest, that's not fair, and it's causing ongoing expansion of problems and prejudice and hardship to the people that are getting entangled in this program.
Definitely. And these excuses, we're talking about the SUV right now, but they're happening everywhere, right? Because we see it on C10s, C11s, maybe less on ICTs. And we're also on the receiving end because it's the business plan, or maybe it's the business plan. And then people are coming back and we're like, I mean, maybe we can change something here and there, but it's not necessarily the reason that they're choosing to have those refusals. So it's been very, very difficult, I think, for all programs as well.
You'll
Let's
remember
talk a little.
infamously with the self-employed, that's exactly what the excuse was. Suddenly it was, your business plans aren't good enough. And we came to you guys and we spoke at length about some of the problems that were happening.
Exactly.
And it's that's what it comes down to. The reason why you tend to think it's an excuse is that the submissions haven't changed, your rep isn't doing something different, your business plans aren't different. Nothing is happening different on your end, on the designated organization's end, but suddenly they're being refused. So every stakeholder, in my opinion, is invested in coming forward with what we're trying to do in terms of accountability, because it's every one of your reputations at stake. What the applicants see is you promised them something that it's no longer being delivered on. They don't care about what was happening in the years before. They just see you told them this set of evidence, these circumstances, these facts should get to an approval, and suddenly it's not. So that's what we're all being faced with. Yeah.
Exactly. And within the team, we also have the capability to see trends of maybe comments that they're making. Officers are mentioning this or that, and we are very fast to act on it and make the change for the next one. But still, I mean, it wasn't enough. So I'm sure it's happening like everywhere and for many different reasons. So we're talking about rejections right now, and Pantea. Why, I mean, you already touched on this. Why do you think it keeps happening, even if it seems that they followed all the rules? um yes, I mean, can you explain a little bit more about that?
I'm not sure whether I want to publicly explain why I really think this is happening.
You can be candid.
But well, at the end of the day, we're paying processing fees for every applicant, right? When you see that the government cannot manage an inventory, but it's still taking applications, in my opinion, there could only be one reason for that, which is that they want your processing fees. Because it might not seem like a lot on a one-person basis, but if you think of, the 550 per applicant in a family, and then multiply it by 4 or 5 for an SUV group, and then multiply it by the thousands of SUV applications that they've received, it adds up to a lot of money. And so, I mean, part of it, maybe I'm just being very jaded. It could also just be sheer negligence and mismanagement. And that has also definitely been proven to exist in government ranks, right? It's just the left hand not talking to the right hand. There's certainly a lot of that as well, but it's some combination of it, because it's a lesson that repeats and that remains unlearned. So that's where the problem is. Yeah. And the other thing is, maybe it's not popular. It wouldn't be popular to pause the SUV program right now. This government saying the only investor type program, and we're going to pause it, they're going to get a lot of backlash for sure. Yeah. But is it the responsible thing to do if that's not who you're intending to see? You also asked like what we think will happen in the program. What happened with the self-employed program after all these years of litigation of proving what your problem is, you're getting applicants that you never intended to apply for the program and that you don't want to approve in the program. So be honest about that. Be honest up front and say, this isn't who we want. So a big part of what was weighing down that program was small-time farmers. Their internal communications and investigations led to the fact that it was a lot of small-time Chinese farmers, family farmers, that were applying for that portion of the program when they were looking for, industrial commercial type farming ventures. So they finally, after almost 10 years of having that information, paused that program. What I think will happen with the SUV program is the incubation level stream of the program will eventually be paused, not closed, paused, because what they're looking for is more seemingly ventures that'll be up and ready to go, that will immediately infuse the funds into the Canadian economy, rather than the incubation level ventures, which often, and it used to say right on their webpage, 99% of them will fail. So that's something that I potentially anticipate as the first level of at least pause, instead of a full-blown closure of the program.
Okay, question for Zainab. What are the most common reasons you're seeing for refusals yourself, and are there any specific patterns or red flags that keep coming up in your experience?
Sure. Just picking up on what the final thing Pantea said, I think the caps that were put in place last year, they're not a pause, but they were intended to reduce numbers. So, and they also came out with some additional requirements as of April 2024. So when I'm advising applicants, I make a very clear distinction of if you're a pre-2024 client applicant versus post-2024, because certain requirements became far more clear as of that date. And during the summer of 2024, they updated some of their processing information and guidelines. So from that point onwards, we have more clear information of how they're going to process things. But the challenge we face, and this goes back to a question, Marinella, of what the key refusals and common refusals are these days, is some of those new expectations that are from 2024 are being applied to applicants from 2020, 2021, and so on. And that's where it's unfair. The other way of thinking about it is we do have some one-off refusals, applicants who have an issue specific to their application where, just as any other application might be incomplete or have problems, then they're being refused. But the bigger thing that we're seeing, and it's, what Pantea has alluded to, is a lot of systemic concerns where it's not just one application. It's the kind of concerns that previously were part of the practice of IRCC to accept, but now they're not doing it. One example of it is the changes in letter of support and the composition of teams. If there was previously, somebody who was essential, and during the processing, that person, for various reasons, was changed from essential to non-essential, IRCC would accept that changed letter of support from the designated entity and would continue to process, and people went on to receive their permanent residence. Another example, unfortunately, of one of those, excuses that Pantea was talking about is something completely new that we saw starting in 2024, which was, for the first time, IRCC was coming back to applicants after 2-3 years or more that they've submitted their files and saying, yeah, you provided your letter of support with your application, but we don't have a record of directly receiving the commitment certificate from the designated entity. If that was really a concern, that would be something you should put on the checklist for applicants to make sure that they follow up with the designated entity to submit that. 2, it's impossible for me to believe that that issue never arose in all the earlier years of this application and only started happening in 2024. Mm-hmm. And it's unfortunately become one of those concerns where it's not really one within the control of applicants, but also something that was never a refusal ground earlier and is now being used. The other big thing that unfortunately is happening is with regards to whether applicants and teams have made sufficient progress. And they're tying this in with whether this is a genuine application and whether there are artificial transactions. I find these to be very problematic because, one, IRCC never set out metrics of what you need to do. In fact, when the program was initially set up, it's right there in the regulations. It says you can have conditional, plans for coming to Canada and setting up your business. It doesn't say you must be doing X, Y, Z, you must hire X people. It doesn't even say you have to be registered, right? And as the processing times have become longer, this has become one of those excuses where they're going back completely subjectively and saying, we're not convinced that you have made sufficient progress. And not only that, but then saying these are artificial transactions. You're only doing this for immigration purposes. And it's highly unfair. And it's one of those things that is unfortunately affecting more and more people. And remember, the quota for the number of applicants to be processed per year was pretty low. It was increased last year to about 6,000, but now it's been reduced to 1,000. And compare that to a backlog of over 30,000 applications. You're either looking at extremely long processing times, or you're looking at trying to reduce your inventory in whatever ways possible. And that's kind of where we are right now.
Exactly. I remember when the start of Visa, its original purpose, it wasn't even like, it was only to bring in talent at the beginning. And then suddenly it was more, okay, early stage startups are okay. And then what you were mentioning also, we want now post revenue, startups who are having results abroad. And then the showing progress part. So they've added all these things that have to do with what Pantea was mentioning about, they actually want something else right now. So if that's the case, I think what we're saying here again is, let's get a little bit more of transparency and coherence between what it is they want in those applicants and what the program really is. So definitely an expectation of a change needs to happen somewhere. So hopefully we can see that soon. We hear a lot about priority processing. What kind of impact, Zainab, is that having on the cases that aren't being prioritized?
That is a huge problem, and the challenge of it is this: the language was introduced last year that applicants who have support from letters of support from angel investors or VCs are supposed to be in the priority stream, and a select number of the designated entities that are incubators are also supposed to be priority. That's highlighted on the IRCC website. The reality has been that, first of all, everybody, as I mentioned, there's thousands of applicants who are in that backlog who are being negatively impacted. And this change is also a retrospective change. I think this is right for litigation that, at the time that applicants submitted their files back in 2020, 21, 22, 23, up until these changes were made in 2024, there was no idea or concept of priority processing. And so for them to be treated in this way is highly unfair. Practically speaking, given the really low number of applications that are supposed to be finalized this year, maximum of 1,000 under the current plan, I anticipate that processing times are going to get longer. Even with this idea of priority processing, I don't think we're going to see quick processing for VC or angel investor applications. But one troubling sign that I've also seen is I've actually seen an application that should be in that priority stream, and I've seen the GCMS notes on the inside, but it was incorrectly coded in that it specifically said, and this was from a designated entity that happens to be on the priority list, and it said, this application is not a priority application. It will be processed after all the priority applications have been processed, right? This raises huge alarm bells in my mind for all those applicants who are not in the priority list. And two, even for those that are, I'm not sure that given the sheer volume of cases that they're being properly assessed and properly categorized either. So I think this is a highly problematic concept that they've introduced. And I think Pantea can talk about some of the potential ways in which maybe mandamus can be used in this space as well.
Exactly. So yes, we've identified and broken down the problem. Now let's talk about what options are there. So let's talk about litigation and legal action. Pantea, what are the legal avenues available to refused applicants today? And when does it make sense to litigate, and when might it not?
So, if you've been refused, pretty much litigation is your only choice. So that's the first group I'll talk about. We've already launched a group litigation. It's before the federal court right now for refused PR applicants in the SUV program. And that for now has 4 main kind of quote unquote excuse-based refusal subcategories. There are others I can envision, and if any of you know of any, have them come forward as quick as possible, and I'll explain why in just a sec. So the 4 subcategories, as the first is that change of LOS, change to the group composition, which was not accepted, and applicants all refused based on the initial essential person issue. The second is the allegation that the commitment certificate was not received from the designated organization. And in terms of timing, what has happened, again, through internal ATIP information, is it seems there was a glitch with IRCC's email address receiving these commitment certificates, the designated one that the organizations were using, around March 2023 or so, for about a period of 2 months. They're in their internal communications. They had a data capacity issue. They weren't getting it, whatever. And so the auto reply that would normally be received when you send an email to IRCC wasn't being sent out. And where the designated organization has at least a copy of the email that they sent out, that is more amenable potentially to settlement. Come speak to us. But if a one DO, for example, does not have a copy of those emails, it's alleged that a staff member was sending them, they're no longer with them, and they, regularly deleted their emails, so they don't have a copy. And where that's the case, weaker evidence, so IRCC is taking that to court. So that's the second subgroup. The third is another action by a designated organization, which is that for one DO in particular, there is an administrative error made in the retainer agreements that leaves in a clause suggestive of the fact that the applicant has paid for their support. And even though the DO has proactively notified IRCC, put evidence on record, sorry, we made a mistake, blah, 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 it came in from our non-immigrant standard retainers and whatnot, they're still being refused on that ground. And then the fourth is where humanitarian submissions that are made have not been considered. So for your attendees, there is a section of the Immigration Act that allows people, with the exception of things explicitly set in that section, to request humanitarian exemption from any eligibility or applicability of other sections of the Act. And so, for example, the fact that an essential person being refused is supposed to cause the rest of the teams to be refused, the group members to be refused, is something that people are making humanitarian requests to not have applied to them. So those are the 4 groups that we have presently: a lead case, a sample representative case, and in the litigation that's already 34 people. The 5th that I can immediately anticipate is those tight timelines. At least a series of people in December, January, for example, were given a huge blast out of give me everything under the kitchen sun, updates, criminality, military, all this stuff, and we're given a 7-day deadline to provide them. I have not come across a case yet where they were refused on the ground of not responding in time. For the most part, people were either able to get extensions of time or at least slap something together in response within that time. So it's a procedural fairness issue, yes, but it hasn't led to a refusal. So if anyone has a refusal, bring them forward. And the reason why it's really important for these representative issues, the issues that we're seeing as potential excuses, having a representative case in the litigation right off the bat, is when the issues to be litigated at a group level are being discussed and decided and finalized and locked in, trying to add an issue afterwards is a nightmare. And in most cases, depending on the judge that you get, which we have for the derivative self-employed litigations, they just won't allow it. So if you have them, bring them forward right away, because they just might not be able to join the litigation after, and then they have to start a separate litigation. And from the self-employed context, I can tell you from firsthand experience, it ends up being a huge nightmare. The second group litigation that's being prepared right now, hasn't been launched formally in the court yet, is a mandamus litigation. And that litigation has several identifiable subgroups as well. It's, first of all the people who've been approved, everything, eligibility, security, everything is done. They're just waiting for passport issuance. And those people are heading up against targets, right? So if you've got a cap announced of 1,000 per year, and each visa post is given a certain number allocation of that, if that visa post has reached the cap, they can't finalize your application even though everything else is done. So you're sitting for the next year's queue and the next year's queue and potentially on and on, even though everything else is done. So that's the first subgroup, the strongest case. The second subgroup is people who have had eligibility done positively, but are waiting endlessly security, 2 years plus in most cases. Lots of case law around that recently as well, that, you know, even if you're waiting for Interpol or other third parties, you can't just sit on your hands and wait indefinitely. So that's the second. The third is people that are in the processing queue that are both being impacted by the prioritization and now going to the end of the line. And even, in my opinion, people that are filing relatively even now, where at the time that you're filing, you are not aware of the already publicly available access to information request information back end that's telling that's conversations between IRCC officers of how long that processing will actually take presently based on those targets. So even though it's posted as 40 right now, and if your representative wasn't aware of that ATIP evidence and files for you, and tomorrow you find out that, oh, I can actually see IRCC discussing their inventory and telling themselves that this will actually take 6 years as of today's date. Wow. So then that's a false promise. So that category is also being canvassed right now, again, for representative cases and whatnot. And because there are thousands of people in queue that this will apply to, the mandamus litigation is expected to be much larger in numbers with much lower fees to join the litigation. So contact us for that as well. And then the one-offs, of course, if it's something that we don't think is applicable to a group level, you'd go forward. I'm going to caution against people that have the group level issues but are proceeding on their own. This happened already multiple times with the self-employed litigation, and it is already happening with the startup visa. As you know, in the immigration silo of Canadian law, you have to get a leave decision before you can get to a hearing. And with the present overwhelm of the federal court from these indefensible decisions across the board, AI and automation based increase of at least tenfold of refusals, federal court is crumbling, really clearly, not even facetiously, actually admittedly themselves crumbling and at its breaking point. But so that means there's a much lower statistical chance of getting leave granted. So even though the argument is strong, like the arguments we're taking at a group level, many are being denied leave to go to a hearing to argue them. And if that happens with your clients, then trying to revive the application is much harder. If they've even gotten a hearing and been refused, it becomes even harder. So I would suggest don't take those risks on a one-off, because critically, what we proved with the self-employed litigation, who during its four years had dozens of people who did the exact same situation on an individual JR and were refused, was that when a decision is looked at in the context of one officer's use of discretion, it could readily be deemed reasonable. It could readily be deemed procedurally fair. It's only when you look at that one decision in the context of the hundreds and thousands of that processing inventory that you really understand the systemic problems, and most likely the calculated decisions behind the scenes by management level that's affecting that processing. So you're doing your clients a disservice, in my opinion, when you go at it alone, because you lose this opportunity. With both the main self-employed litigations, we got leave before even filing the legal records. The the applicant's record and that set of arguments. So that just explains to you what the different landscape is. And I think that the main benefit of a group litigation is that it has the drawback of being longer in its litigation process and lifespan than an individual litigation for that reason, unfortunately. But then you get the highly increased chances of getting to a hearing and potentially getting a positive outcome as a result.
And talking about the timeline, Panthea, what kind of timelines are people realistically looking at for group action?
So an individual JR, depending on the court's craziness at that time, usually takes a year to year and a half. A lifespan of a JR is a year to year and a half. What happens with managed litigations, group litigations, is you still have the JR process of a year to year and a half, but ahead of that, you have what's called the case management process. And the case management process is a mini trial process, essentially, where you kind of duke out the issues to be argued at the group level, the manner to do it, the timeline to do it. And so that can add on, depending on your case management judge, depending on how cooperative the minister is, anywhere between 6 months to years, unfortunately. So that is the biggest drawback in group litigation. And one of the additional things that I'm doing at the group level is actually challenging that case management process, because the federal court is, the design of it enables it, but it's not with that process really in mind. And it doesn't really have, it hasn't really considered that becoming a more dominant part of their inventory, and really turning its head to procedural issues, helping applicants in that process, because a lot of times you're expected to prove things which, of course, you don't have upfront. You need to go through the litigation process to get that, and without that, so for example, in the attendees might know, we did a huge self-employed litigation called Tafreshi with an amazing judgment, an unprecedented cost award. And then we've had 3 group derivative litigations thereafter. When we did the second group litigation, the third and fourth were already envisioned. We knew those subgroups of issues were happening, but we didn't have a representative client come forward. So even though in the second group litigation, we talked about it, the judge knew we're waiting for this, like this is already happening, IRCC is doing this, they're having refusals like this, whatever. We didn't have the case, and so it didn't form part of that litigation. Subgroups went forward, third, fourth litigations, and then we tried to get them grouped together. It didn't work. There's an issue with it, and you don't get appeal rights in the immigration context. So it becomes really, really problematic. And so all those same issues we're facing right now with the SUV, and what I'm doing within the litigation and outside of it. So the federal court has asked for all kinds of feedback, input through its rules committee, through its targets, a bunch of different avenues, 3 different avenues that it's come out to stakeholders, including lawyers, for feedback. There as well, I'm speaking of the need to better systematize this case management process. So what was happening is, even though I, as applicants counsel, can see the interrelation of these groups, of what's happening, and the fact that the evidence from this will be required to show what this person's saying, the court doesn't know that. The court doesn't see that, because they don't have the 10,000 pages of evidence I've already put into record at that stage. And so they fight you. They say, no, I don't see a relevance between these cases at all, which from my perspective is mind-blowing. And when we then have to go to 3 sets of hearings of the same evidence, it's going to become mind-blowing for the court as well, that they missed an opportunity to consolidate them and have just that one hearing. But that's also the problem. They need to be more alert to the fact that we as applicants counsel, we as stakeholders will have a better pulse of what looks and smells and quacks like a systemic-based problem, then the court will readily be able to see without that evidence up front. And so we're pushing on all channels for those changes.
Well, and thank you for that, Pantea, because I mean, clearly it's a lot of work, and that's also the reason why we're here, right? We're giving options, but also understanding that if it's done together, it can have a better outcome, right? So if any of the immigration lawyers or consultants that are here today have any of these issues with some clients, reach out to Pantea. We will be providing the information on the chat so that people can do it together and not individually. A question for Zainab. Do you think that all these legal efforts that are is there an impact, or is it still an uphill battle?
Well, it is still an uphill battle, unfortunately. Like, I think we have to be very realistic about that. I think that this kind of litigation will help because it will put IRCC on notice to be more careful in its decision making. But, you know, it's a double-edged sword. It might prevent these specific refusals, but it doesn't prevent them from coming up with new excuses. So, you know, one thing that I do want to just make sure that we emphasize today is to the extent possible, you want to try and avoid refusals. On certain things, it's going to be impossible to do because of these kind of systemic issues that we discussed. If they pick up on something and they want to go and find every case, then it is what it is. But let's talk about, for example, their requirement for showing progress. This is something that I've actually been talking about for years, even before these refusals came about, that the startup visa program is not a passive program. It's not something that you can rely on in the future. You're going to be able to say that, you know, I will do my business when I come to Canada. You have to be actively running your business, and you have to be gathering the evidence of it. So a lot of the people, for example, that are being refused based on lack of progress or artificial transactions, they have not been able to convince the officer at the PFL stage, the procedural fairness letter stage, that they have sufficient progress. And this is something that we can work on. You should be, if you have clients in the queue or clients starting out, advise them that this is something that they have to take extremely seriously. They have to have systems in place for documenting what they're doing. It kind of ties in, you know, with the kind of work that you guys do, Marinelle, in terms of business plans, right? Yes. Not just having a business plan, but what are the milestones? What have you promised in that business plan? Because now when they're trying to find, you know, something to hang their hat on, they're like, well, you said you were going to do X, Y, and Z, but you haven't done those things, right? It's really working on the business and being 100% committed, and having not just one person committed, but all the team members contributing to that, being able to document that. And typically when you get that PFL, you know, we had some circumstances. I was one of those people who lost my winter holidays trying to, you know, get updates together for people. But typically you have about 30 days. Like, if it's shorter, then you ask for an extension, but you shouldn't be counting on more than 30 days to respond to that kind of request. And it is way too late. If you get that request letter and you start to put documents together, the dates will be as of the date that you're putting the PFL response together. You just will not be able to do a good job. And you can't show that depth of work over 2-3 years. And that's why, you know, if anybody comes to me and they're talking about, I want to apply under this, I'm like, you should only do this if you are actually going to commit to it. And for anybody who's already in the process, they should be fully committed to it, going back, reviewing their evidence that they provided at the front in terms of their business plan, and making sure they follow up, updating that, so that when they get to that PFL, they're going to try their very best to convince the officer that they are one of the genuine applications, to try and avoid that. But unfortunately, given everything else that's going on and the overall, you know, shift in immigration policy over the last year and a half of being far more exclusionary, if you do face a refusal, it will be very difficult. And that's why, even though it's longer, group litigation may be the only option that applicants end up having, because, you know, getting a new letter of support might not even be possible for a lot of applicants to try and do a reapplication.
And if I can add to that, in terms of trying to avoid that refusal, the going all in is a double-edged sword, right? So clients always come up against this on the issue of whether to get a work permit or not, right? And this is part of the things that we were all envisioning about 3 years ago or more, when the program was really starting to get hot and taking over. Certainly, these SUV groups, many of them will fail, right? So if you're getting a work permit and going full force ahead, and the processing time is taking 6+ years, by the time you're getting to your PR assessment, potentially your startup venture has failed, right? And so will that be an additional excuse that's used to refuse your application on the false promise of having lured you into the program in the first place and all that? So some people are taking the strategy that, not even the strategy, it's a real life situation, which that they can't invest their time and effort and money to launch 100% forward until or unless they know that they're going to get that PR. And so, yes, that is sometimes being used as, okay, so then you must not have a genuine interest in this and whatnot. But it really needs to be, that's what advocacy is for, right? That's what your representatives are for. Whichever way you go on that decision, you have to be able to defend why, based on your business needs, based on the initial business plan that you put forward, one or the other makes sense. For example, some design of a project, as stated in the business plan, is not conducive to being started ahead of time, ahead of getting 100% work permit, at least, if not PR. So, for example, Iranian applicants have, boomed into this program, and they face a lot of sanctions if they're operating out of Iran, right? So if your business idea requires, lots of banking moving forward and patenting and this and that, you can't start those seeds from Iran because of those sanctions. So you must at least either get a work permit and come here first, or you just wait fully for PR. So be very careful. Go back to what Zainab says, and I'm so shocked by how little that is given weight when people are making, especially, let's say, temporary resident applications relevant to this. What you have stated as your intentions in your initial application, in your initial business plan, is your Bible going forward. You need to know it, you need to live and breathe it, and that everything else that you're filing, even a visitor visa application, has to be congruent with the intentions that you're stating there. If it's not, then you're inviting the opportunity for a reasonable refusal, not even excuse-based at that point. That would be deemed a reasonable refusal because, like we're seeing in the one-off cases, it would be reasonable to expect X, Y, and Z when they're not looking at the systemic context of these assessments.
But now we're going back again to the government expecting things beyond requirements, because success was never a requirement, right? And now it seems that everything is pointing towards that.
Not only that, sorry, if I can say one other thing. Shockingly, in terms of things that are being required that weren't part of the design, by design of the program, IRCC said, I am not well fit, equipped, or trained to make business decisions. I am subcontracting that out to the designated organizations. But now, lo and behold, you get their commitment, you get their support, and now an officer with absolutely zero training in business analytics, in business plans, in accounting and marketing and the like, is asking you for updates and, what have you done towards your business, and quantify your business your potential financial contributions. They're not equipped to make that assessment. So why are they even entering that forum? Why are they even entering that assessment? It's a double jeopardy situation. I mean, it has legal terms, but that's part of also the backlog, right? Suddenly officers are revisiting all those business decisions when they shouldn't be by design of the program in and of itself.
Can I just add something in here? I think all of this goes back to the way that the startup visa was envisioned, the minimal requirements that were put in place back in 2012, 2013, envisioned a very small, very specific program focused on tech innovators, young people. Some of the early applicants that we had were, it doesn't require a university degree, for example. They were university students who barely had enough funds for LICO. And I've followed them as they've gone on to become successful, running $1 million companies here in Canada. So the vision was right at the beginning. And the problem we faced over the years is that because we don't have other business pathways, this program has become oversubscribed. And for many years, IRCC should have stepped in to, one, create other pathways, but two, prevent the issuance of letters of support for thousands and thousands of applicants. One, that they knew they weren't going to be able to process, and two, that we're not really, in line with that tech, high growth, startup focus. When we think startup, we're thinking of like Shopify and Facebook. We're not thinking of a small business, and that's the mismatch. And we're sitting here trying to figure out how to fit all these circles into these, square holes, which is not going to work because processing times don't match up with the requirements of the program. Like nothing fits together in this puzzle. I kind of feel bad for the officers. Like they're left with piles and piles of applications. Yeah. There's also ATIPs on this where they're highly frustrated with this process of, they have an idea of what the program is supposed to be. And at one time when there were very few letters of support being issued, they could take confidence that the letter of support was in fact, a reflection of that expertise that the entities had in assessing it. But now they're getting thousands of letters of support from the same designated entity, hundreds coming in per month. And they're wondering if that, I can't fault them for going back and reviewing it. But at the end of the day, it is still IRCC's responsibility overall as an organization to step in and say, we made this mistake. We should not have taken in so many applications. Now, this is the way we're actually going to process them. I think realistically, but I agree with you. I think you could make the argument that someone might not make an investment, might not start the venture. But if it's 6 years after, then realistically, what's that going to look like? And this is where IRCC should step in and be like, okay, we said this at the beginning, but if you want to continue, these are the things that you have to do. Mm-hmm. And if you don't want to continue, we can give you your fees back, right? At the very least, like some way of being very honest and transparent about this, as opposed to keeping it all super murky, doing these things sort of backhandedly. And the ones that are genuine, that are trying to do things, startups do pivot. They might start out doing X and then they, go to Y and Z, but they're the same team of people and the same sort of general ideas are there. So people could do that, but IRCC has to be more active. And I think they have so many things going on at the same time that this is not a priority for them. And this is why we're here having these really difficult conversations. And it's extremely difficult to provide advice to clients who are in the process of, should you do things or should you sit, in your home country and wait? There's different strategies. I still think if you do the work, even if you're not here, like let's say you applied for the work permit and were refused, you still show that you've taken as many steps as you can, then it works. But as you said, Padilla, there are some circumstances where you can't do that. And you have to
at least... And what happens to your business idea in the meantime, right? These were meant to be like cutting edge, new technology type things. So people are stealing your ideas in the meantime because you're being prevented from moving forward. Like it's just such a mess. And it's a really tremendous loss for Canadians that this program isn't a priority, because it's meant to be not only bringing in tremendous, not necessarily bringing in, but at least generating tremendous economic boom for us, but also, potentially very highly trained entrepreneurs and the like. So it's, how I think of it is, if this program, which is, for the astute and wealthy and whatnot, isn't getting any attention in immigration processing, can you imagine what the refugees and the family sponsorships and the like are experiencing? Like, this is how sadly broken the system is.
Exactly. So we have, to round up the whole situation, original expectations of what programs were, the mess that is happening right now, alternatives that you are talking about, thankfully. But at the end of the day, hopefully that uphill battle would help people who are joining the group litigations, but at the same time make IRCC realize that they need to reset their programs to be aligned to exactly what they want today. right?
So if I can just pick up on that point, because I think it's very, very critical. Making IRCC do something by court judgment that they aren't willing to do by themselves, right? So the hope of these group litigations, was to say, okay, smarten up. The court's telling you that this is really wrong behavior and do it differently. I'm not convinced, sadly, that that's going to happen. Maybe it's because I'm really in the trenches, like in the litigation side. But if people understand the immigration litigation context, costs against the government are not allowed except in the most egregious of circumstances where you can demonstrate special reasons, special circumstances, right? And where they're awarded, it's in the 500 to 1,500 ranges. I just saw an ATIP yesterday about how they do their cost payouts. And when it's under 500, it's just a general manager that authorizes it. It goes on, whatever. Up to 25, and then something different happens after 25. It has 3 layers of management that needs to approve it. But in the Tafreshi litigation, in the self-employed litigation, we got an unprecedented cost award of $50,000. That was the court saying to the government, you are doing this all wrong. Don't make calculated decisions behind the scenes, because it was proven that they thought ahead and said, okay, this is going to cause a lot of some people to litigate, but when we think of the cost benefit analysis, getting rid of this inventory versus how many will litigate, it's better for us to do that, right? So they gave a big cost award to say that calculation in numbers does not equate to human lives, so don't do it that way. The $50,000 cost award didn't make the slightest dent. They moved on from that litigation in the same category, did the exact same thing again and again. So there's a limit to what we can achieve through the group litigations in the judicial review context. So now a new tool that I'm working on is actually suing the government. So actions suing the government is where you're allowed very significant cost consequences. And that's where I think is truly the place where you can make a dent enough to cause a change of behavior. The first group that I have in mind for that, and I'm selecting, and if your clients are this, please let me know. People in this program will know that about 2 years ago, there was the work permit issue. The wrong codes, slew of work permits in this program were being refused because IRCC told you to put one code, officers were trained that you were supposed to apply a different one. IRCC has, again, internal communications, publicly released ATIPs now that admitted, we made this mistake and we think it applied. I think the ATIP said like 89 applicants. It was more than that, I think, in reality. But it said, we know it applies to that many people. They did nothing about it. They didn't change it. They didn't reach out to them and say, we made this mistake. Those 89 plus people should come forward as one class. You only need one applicant, and I have one applicant, but of course you need the rest to fund that litigation. I think they should sue the government for having done nothing, for the hardship that they caused them. The action requires a clear demonstration of the damages you incurred. So aside from maybe litigation fees, because I couldn't come, I had to pay international student rates for my child. I had to do this. The business couldn't go forward. We had to hire someone on the ground to do what I would have done, blah, blah, blah. You need to come ready with those kinds of damages, but that should be the first group that litigates clear and simple and says, you clearly knew you made a mistake and you did nothing about it and it caused me hardship. The second group that I'm percolating for that is the refused SUV applicants that are now joining the group litigation on the refusal of their PR, but then move forward to sue them. And you have 6 years to sue the government in these contexts. So I would have done it with the self-employed applicants for sure, but money, they ran dry of funds many years ago, and I'm just doing the work, unfortunately. But with the SUV group, who's better funded, we really stand a chance to do this. So reach out on that ground as well. I think that would be a very important tool in our toolbox to change this type of behavior.
Thank you, Pandra, for those options. And I'm sure many people that are listening are going to reach out. A question for Zainab before we go to the Q&A. If you could change just one thing in the current system to reduce the widespread rejections, what would it be?
A It's kind of like the genie, I would wish for 100 wishes. That's my thing. But, I think the biggest thing is transparency and having a clear understanding of what the expectation is. There are certainly expectations that officers have when they're reviewing these applications that are not communicated in the guidelines, in the regulations, and so on. And I think there should be fairness in terms of providing that information. So what metrics are you using, right? I keep going back to that word, because if you don't have it very clearly, then applicants just don't know the case to be met. And I would also say, I think IRCC should make an exception, and they should process all of the applications and, allocate a much higher number to this program compared to the 1,000 that's currently allocated. Because once they do, it opens up their hands. They can be much more flexible, and they will have the same sort of approach that they had previously in terms of being able to understand the realities in which people have been waiting and have been, many times working hard for their applications and want to come to Canada. Remember, every time people have a really bad experience as part of their immigration process, that's going to color their whole view, even if they go on and become permanent residents. And we're looking at highly talented, well-to-do applicants. And if we don't welcome them, or we don't give them a good experience in the immigration process, I can envision a lot of them, when they become Canadian citizens, might not have the same loyalty for staying on. And that is another missed opportunity. I think it's very short-sighted when you only look at it as, we let in whoever we want and we don't whatever. But even the ones that are accepted go through this unfortunate hell of limbo and uncertainty, and once they do make it, they don't forget that trauma.
Exactly. Definitely. Thank you. Okay, let's go into some of the questions. I'm going to pick some of the ones that are in our tab, and also a few of the ones that were submitted during the registration process. I have a question from Anu Lal. I heard of 2 cases where, after the PR was approved 2 years ago, they are asking about the progress and current status of the project now. I don't know who wants to take this one.
I asked Anu in the chat if that was after they were received their PRs, and he said yes. And I'm quite surprised by that, because there's no space within the startup visa for, in terms of the legal structure of it, for there to be follow-ups after the fact. There might be, in some circumstances, if they obtained a work permit, they might be coming back to do compliance on the IMP, the International Mobility Program compliance, just to make sure that for that period of time that the work permit was in place, they followed whatever requirements. But I'd be curious to see if there's actual documentation. Sometimes people say things, and if it's not your actual client and you haven't seen the IRCC letters, I would be hesitant to believe that. I haven't seen that happening. I don't know, Pante, if you've seen anything like that after they get their PR.
Yeah, that it's very interesting to hear, and for sure, of course, I would want to litigate that, because the legal avenue mechanism by which they even gain the right to ask any questions is, for the legal box, section 16, that says anybody that makes an application must answer truthfully. So once the application is finalized, their jurisdiction to continue to ask you things is done. There used to be oversight of the business programs a long time ago, like 15 years ago. They had a unit dedicated to business programs where you would do follow-ups. It was part of the program, though, that you would report on your business developments within 2 years of coming. And so the jurisdiction continued for that two-year period. But presently, if no one has made an application, that's what Zainab's talking about, maybe in the context of a work permit application or something. But if you haven't made a new application, there is no jurisdiction for them to ask you those questions. So get a good advocate, get a good representative that will push back. What happened with the Tafreshi litigation, after we won in court and the applications went back for redetermination, like I said, the government didn't listen. They did the same thing, imposing a new round of unexpected standards to be met, again, even on those applicants that had a very specific and circumvented court order. And of the people that were in that redetermination process, not to toot our own horns, but 17 of them retained our office for the redetermination phase. And all 17 of them, except for one that's still pending, which is also being litigated, were approved. And why? Because when they were making those additional requests, I pushed back. I said, what's your authority to do that? The court order says you must apply the standard to be met that was in place at the time that they made the application. So this quantify your significant contribution, now give me an IELTS result, and things like that are not part of those standards. And in every time that I pushed back, they got an approval, but many of them did not, sadly, and they're now the fourth group litigation in the self-employed group having to come back to court, unfortunately. So push back. If you're seeing that situation happen, push back on their authority to even be asking you that.
And one
Join
thing,
the group.
sorry, I would just add this. Make sure, I don't think this is your case, but if it is, you want to make sure it's not a misrepresentation issue, because that's slightly different to what we're talking about here. Because IRCC does have the ability to come back later on any application where they later discover that there was misrepresentation. But it doesn't appear to be that, because you're talking about progress. So I agree with Pantea that there is no requirement, right? This is not conditional in the same way as the entrepreneur program, the federal entrepreneur program was before. But without knowing more, we really wouldn't be able to sort of determine what's happening there.
We have another question, and I think, Zainab, you posted a reply. Are you aware of any applications submitted under the priority processing since May last year that already got processed and approved? Not yet.
I'm not, no.
Okay.
I'm not, no.
How long does a right of mandamus take for checking delays in processing? Sanjay. Hi, Sanjay.
A mandamus is just like any other application in federal court. Its full lifespan would be a year, year and a half. Same with group litigation, it would add that additional thing. The only difference with mandamus is your ability to pursue that legal case could be mooted by the fact that IRCC starts processing, because what you're asking for on a mandamus is for the government to process your application. And if they start processing it, and sometimes they might do that strategically, they'll process it so that you can no longer proceed with the court application, which is a win-win either way.
Okay, I have another question. Mohsen says, unfortunately, a lot of applications are being refused again for the same grounds or even new grounds after they are settled or JR granted. What legal action can be taken for them? I think we touched upon a few of these, but if you can maybe repeat briefly, that would be great.
Pantea, before you go ahead, this is happening a lot for non-SUV JRs. So, for example, if you have study permits, visitor visa JRs that were successful in court, unfortunately, what we've seen, particularly since, I think, Pantea, you probably can attest to this too, since January, IRCC's process has changed. We have seen more refusals since January than we have seen in all the prior years combined for exactly similar applications that were going back and now they're being refused. It's a little bit different in the SUV context because we're not getting settlements. I think there's a very clear policy decision at the Department of Justice and IRCC not to settle the SUV cases as easily. But Mathieu, have you seen the same thing with increased refusals post-JR as well?
Yeah, for sure. The automation stick is hitting everybody, unfortunately. That's mainly happening across visa applications, the temporary residence, but it does happen, unfortunately, in the PR context as well. Where that happens, sadly, yes, your recourse is court again, but know that every time you have to go to court, you can increase the strength of the remedies that you ask for. So normally when you win in court, all you win is an opportunity to have your application reassessed by a different judge. But if the circumstances really demonstrate that the government's not going to make a reasonable decision, then you can ask for what's called substitute judgment, which is quite rare. In the present context, I'm asking for it more and more. I'll be asking for it in the group litigations. And that means that you are basically asking the court to make the decision that the government will not make a lawful decision, to remove that decision-making power and for them to substitute a positive decision in your end immigration application instead. So sadly, if it comes to that and you have to keep going back to court, just you can elevate your requests and costs and things like that. But sadly, that is your mostly only opportunity, because you used to be able to do emails to post managers. You used to be able to get their attention through call center and the like, web forms. They're not listening to any of those access points anymore. So by closing those access points, they are forcing and funneling you into the federal court process as your only option, sadly. So while I have heard, Zainab, I don't know if you noticed this on the listserv, I have heard of at least one case in the last year where there was success with a post manager to overturn something that was like really obvious. But we don't even do them anymore. We don't even reach out by web form or to the post managers because it's proven to be so ineffective and a waste of time.
I will just add to this. It's not exactly on point for this conversation, but I have found reconsiderations to be used against applicants these days. And the way that works is that particularly on a lot of the automated refusals, they will write some generic things that it's much easier to overturn in judicial review versus when you submit a very complete reconsideration request, they go in and they, add additional grounds for the refusal. I've seen this also on PR applications, not necessarily on the startup visa, but in other contexts where they will say, okay, well, we'll take these issues into consideration, and they will add additional grounds for the refusal. Now, we could try to refute, say that, we're JRing the original decision, but I don't think it's worth that risk. Out of everything that I've seen over the past, particularly 5 years, I've only seen maybe 2-3 cases where reconsiderations have been successful. So it's not something that I do in my practice anymore. Not only that it's a waste of time, but that it creates this risk as well.
So on that point, again, unfortunately from the litigation standpoint, for your listeners, reconsideration and a decision on that is considered a new decision. So that's subject to a different application for judicial review. You couldn't just, you could ask for them to be joined, but they're not considered the same. And be very careful. You do not get an extension of time to JR the first just because you made a reconsideration and you're waiting for that outcome. Be very, very clear on that. But strategically, I will let you know that oftentimes, Zainab, unfortunately, is giving the government too much credit. It does happen for those officers that are paying attention. They do go in and litigation proof. It's called litigation proof. If you ATIP that, you'll see. They have this term, which means they fortify their reasons for refusal to better stand up against litigation. And I can explain why that is if we have a few minutes. But otherwise, that aside, where you make a reconsideration request, oftentimes what is happening right now is you get a blank statement that says, we've considered your request, it was rightly refused, submit a new application, just like a sentence. If that is happening, that the JR of your reconsideration is stronger because they have an obligation to fully consider the submissions that you're making and things like that. And so that gives you potentially the right to have your reconsideration properly looked at of the original dismissal. So it might be a back end where you think the original dismissal is refusal is either time barred, like you can't explain why you took so long to come forward, or some other reasons that make you prefer to JR reconsideration than the original. That might be a strategically better tool sometimes.
I have a question from Arsene. Where can we access some of these ATIPs that have been mentioned?
Oh my God. Follow Stephen Morins and Will Tao on LinkedIn, X, all that stuff. They are prolific in sharing ATIPs. And if you're a lawyer or a consultant, there's also something called LexBase, which is an internal service that you pay annually for. They also do a lot of, before Stephen, I think LexBase was the largest ATIP requester in the immigration sphere anyways, but those are my go-tos. And then I, of course, do ATIPs of specific things that I need to look for, and then they come out in our litigations. Actually, but I should post those too. That's interesting.
Okay, we're gonna go with questions for 10 more minutes until 1. So I have a few. There's a follow-up question from Sanjay. Which year startup visa applicants should file a writ of mandamus as per you?
Everyone. Like I
Okay.
said, everyone in queue, basically, because of the way that I'm strategizing the subcategories, the ones that are in queue longer have a genuine normal, what you would normally consider as mandamus, like you've been processed for too long and things like that. But I'm going to try a new litigation and argument strategy, which has not, in my experience, I researched it, I didn't really see it happening in mandamus, which is to argue this thing called legitimate expectations, right? So in the mandamus context, generally at least 1.5 times the promised processing time has to have passed before you really stand a chance at saying it's been too long, make them do something. Okay, that's generally the principle, 1.5, and however much longer than that it is, it's better. But what I'm hoping to argue, and I hope the litigation strategy doesn't release and get done badly before we get up to bat to do it, is to argue anticipatory breach, basically, in the contract context. It's to say that you are being lured into the program under false pretenses based on this administrative principle of legitimate expectations, that you have a legitimate expectation to have your application processed by in and around the timeline posted for the processing time, because the government admits this is just for 80% of the applications. Some with, case-specific situations will take longer. So if it says 40 months, I think a general rough estimate, okay, even 50 months should be okay. But if the government has internal communications as of a year ago acknowledging that it would take more than 6 years to process the inventory it had then, and it's still promising 40 months now, that's a lie for all intents and purposes, right? So in that one subset of mandamus, which will have the hardest argument to make, so you would have to be amenable to risk to come into that group, because it's a new argument to make. That would be the argument, that they're luring you in basically under false pretenses. But otherwise, anybody that's I would say has everything, including the security done and pending for 6 months or more, is a very good candidate for the first category. Anyone who's had security pending for best 2 years or more, but even less potentially, is the best candidate for that category. And like I said, pretty much anyone for the third.
Okay, I have another question. Is IRCC closing the door on the startup visa program? Do you foresee that there would be a suspension similar to the self-employed stream? Who wants to take this one?
I think that's a good question. I think they did take that big step last year of reducing the numbers. There's about 80, 90 designated entities, so that corresponds to at least about 800, 900 applications still going in per year. But are they going to take another step and maybe, cut down their existing inventories? I don't know. I hope they come up with a fairer solution, but it's very, we can sit here and talk about the challenges, and I think they are aware of the challenges, but the problem has gone so big, it's difficult to approach it from any aspect, right? You're going to be disappointing people. And I'm sure there's a lot of pressure on them from the designated entities, from applicants, and so on. I just hope they don't wipe out the problem, which would be like, let's wipe out the inventory, which they have done in the past. But I don't know, Patia, what do you think?
I think as far as options go, I'll give it to them. They actually did somewhat good. Like, of course, they're going to, disappoint some portion of the stakeholders no matter what, but they did something to reduce the inventory, which is sharply cut off the number of letter of supports and commitment certificates that could be issued, that immediately like pulls down the inventory to 1/10 of what it was annually, basically, because some designated organizations had over 1,000 when now they have a max of 10. It impacts their business, of course, but and then the other thing that they did, which what we're saying, be honest, if the incubator portion is not what you were looking for, pause that inventory. They've done it back end. Instead of pausing that inventory from coming in, they have taken the inventory that they have and said, we're going to pause processing of those applications. What the priority stream inversely means is we're going to prioritize the ones that are ready to go at the angel level, ready with investments to come right into our Canadian economy. And the incubation level applications and SUV groups that are largely in the inventory, I would imagine, I don't have the stats on this and the ATIP, but I would imagine the largest part of the inventory is the incubation phase. And so what they've done is said, given themselves the right to pause the processing of that entire vast amount of their inventory. So, and this is not popular, and I talked on a couple of other situations on this as well. They should pause the inventory explicitly, or at least for the incubation phase, to be honest about what they're doing, at least now going forward. But those that are stuck in the inventory, you're going to have the back end impact of it.
We have a question from Taiping Lee. Thank you for your question. Now the new SUV applicants can receive 3 years open work permits. What about the applicants who received 1 year closed work permit before? Would they get the rest of the 2 years work permit when they extend their work permit before it expired?
I think we always had this before. If you already had a 1 year work permit, you would extend like on an annual basis and you would get a 1 year extension. The way we've approached it for applicants is that if they're in Canada, their closed work permit is expiring. We're now applying for the 3 year open work permits. Like we will say we want it for 3 years, not that only 2 years. And so at least I think that's a recognition by IRCC that their processing is going to be long. So I don't think you need to limit yourself to 2 years. You can apply for the 3 years, yeah. As long as the passports are valid, yeah.
Okay, perfect. So we do have a few more questions, but some of them also are very specific. So we shared the information from Zainab and Pantea on the chat. So if you have any specific cases and things that you want to discuss, we would encourage to reach out directly. Closing remarks. Who wants to go first?
I can do it. I think Canada needs to have a broad range of immigration programs. It's good for the ability to get entrepreneurs into all the communities across Canada. And the startup visa should remain, but it should remain a small program, sort of what it was envisioned to do. But we need to have an investor program like we used to have with better, oversight on it. We need to have entrepreneur programs, and we need to have pathways for a lot of our self-employeds that are coming in. I think that it is possible, and we see it across other countries and also within the global talent stream work permit situation, where the government can do a really good job of processing applications if it wants to, if that's the priority. Mm-hmm. And I think we just need to keep knocking on doors and telling them this is important, this is a priority. And I really hope that they do include that in their basket of, dozens of different immigration programs that we have, but we just don't have enough immigration business options.
Yeah, I echo that completely. So I'll just add on to it in terms of what to do now. I highly encourage everyone to get active. Don't just be sitting ducks. This has happened. There is lots of problems in the program that you may or may not have been aware of. For representatives, increase your awareness, increase who you follow, these ATIPs that are being shared that are critical to you being able to better advocate for your clients and better inform. There was a question about, okay, so what do we do if people want to come and invest and there's no other program, should we still do this? What I say is, you can responsibly still pull people into this program if you tell them what the problems are, the processing issues, the timeline, whatever, but don't blindside them. Don't say, okay, yeah, for sure, come, let's do more. And then once they're in the queue, for them to discover all these problems, that I don't think is fair. But otherwise, sure, if they're willing to take the risk and don't necessarily have other opportunities, which most don't right now, they should. But otherwise, the real true cream of the crop of this program really does have other options. They could go to other markets internationally, and they should have the option if they know the circumstances. But aside from that, please contact us if you have any of these specific types of circumstances we've discussed, even just to share your evidence with us. Even if you don't want to join the litigations, please help improve the circumstances for everybody else by sharing your circumstances, because that's how we won the self-employed litigation. What we did was prove that the contextual thing that we proved was both at that specific visa post, we got, thankfully, people were extremely kind to release their personal information. We got examples of people processed at that visa post before the litigation who were approved on much lower standards and everything compared to them. And then we got comparison of people processed at the same time at different visa posts at London and the like, on different standards, same category, like, versions or this, that, whatever. And that comparison evidence is what was able to demonstrate the systemic problem with that period of processing at that visa post. So I, highly would welcome and encourage each of you to share your circumstances with us, provide evidence. If you, like Zainab, comes across something related to this program or a case or whatever, she emails me. It's fantastic. It helps. It tremendously helps, because if you understand it, you won't, but there's a lot of work that goes into this, and it's just me mainly doing it, right? So it's just impossible for me to keep up to date with everything from every corner and every kind of example. So bring your examples, bring your evidence. And if you're in those circumstances, consider joining the litigations. If you're a representative, please do your clients service. If you're considering proceeding with an individual JR, tell them about the risks. I'm not saying don't go it alone, but at least know the risks. Know the risk of not getting leave, of even when you get leave, getting a negative judgment, all the same things that happen with the self-employed litigation, right? So in the dozen cases that got the negative judgment, where at the same time as Tafreshi, now most of them have joined the second litigation to try to overturn the negative decision they got at the individual case, which is if they had joined the group, they would have had the positive. So save your clients that kind of hardship, now a 2-year litigation that those people are a part of just because they didn't join the litigation when they had the opportunity. So yeah, hope to be working with many of you going forward.
Wonderful.
And I want to give a shout out to Joorney. Joorney's awesome, by the way. We welcomed this this panel because Joorney has been so much more than a business plan writer and whatever. They've been an active stakeholder. They are engaged and genuinely care about their clients. Aside from doing the business plan and doing any type of revisions that you want, they're fantastic at doing revisions that council asks for, first of all. And they are trying to, empower you guys to be able to do more. It's not just out of self-interest because, like you're going to take issue with the business plans. It's been proven it's not their business plans that's an issue. They are an active stakeholder. They are actively trying to push the needle forward in these circumstances and care so much more than many others do. I genuinely highly recommend them and thank them so much for having this discussion.
No, thank you so much. It really means a lot to us because, as you know, I was actually going to thank you for being such advocates on these topics. But on the side of Joorney, I mean, besides doing the business plans, we like to share knowledge, and you have tons of it. And just showing people that there might be options for issues that they face, and that resonates with us, and we want to be extremely have solidarity with our partners, our clients, because we're all here to make sure that we impact people's lives, right? I think we all agree with that. So thank you so much for the kind words. And thank you for being here. We appreciate everyone who attended and our wonderful guests. Thank you very much.
Thanks for having us.
Bye. Until next time.
Good luck. Bye.